one of the proud promises of the civilized world has always been law, order, peace, and discipline, have long formed the basis on which countries were classified as first world or third world.
People in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for themselves a little bit boring.
Administrative justice in Ukraine is a sphere in which the resilience of the rule of law is tested on a daily basis.
The Supreme Court of Sri Lanka found the former executive of this country liable for breach of constitutional duties. Rule of law has been advanced in its full plenitude in Sri Lanka.
Even the highest office be subjected to constitutional scrutiny.
We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution.
Across Europe and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed.
In Hungary, judges are not allowed to express political views.
Why is defiance of the rule of law gaining political appeal across the world?
Rest assured that the judiciary holds the final move.
We can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them.
Politicians must not interfere with the substance of judicial decision, but the organization and financing of the courts is a democratic issue too.
For one, never ever give up.
We simply need an openness to listen.
Thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
It's now my great pleasure to invite the Honourable Justice Dr. Omar Joaquín Barreto Suárez from the Council of State of Colombia to deliver his response to the guest lecture.
Thank you. Good afternoon. Honourable Judge Kuusiniemi, Dr. Nauman, the distinguished judges, colleagues of the Global South Network. It's an honor to participate in this conference from Colombia. The questions that bring us together is urgent. When the rule of law faces institutional challenges, what do the courts do? I'm going to respond with the specific experience of the Council of State of Colombia. What is the Council of State? The Council of State is the highest court in matters of administrative law. It was created more than 200 years ago in 1817, taking as reference the model of the French Council of State. For this reason, we share the same double function, to be consultants to the government and to be judges before it. For many decades, its function was exclusively consultative. It was only at the beginning of the 20th century that it also assumed the jurisdiction function. With this summarized resolution of disputes that arise between the state and individuals. It is divided in 5 sections that resolve issues in different areas, like labor, contractual and non-contractual liability of the state, tax, electoral, and a chamber that resolves a wide range of disputes. The Political Constitution of 1991 protects the broad Charter of Fundamental Rights, and it's one of the most guarantee-oriented in Latin America. But a solid constitution is not enough. What makes the rule of law work is that the public powers are independent and their decisions are respected, even when they are against the government of the day. For this, I am going to give as an example 2 recent decisions that had an impact at the national level. First decision, the suspension of the minimum wage decree. In 2025, the national government issued a decree to set the increase in the minimum wage. It was a measure that affected millions of Colombian families. The problem was not the increase itself, but the way the decision was made, because Colombian law requires that the minimum wage be defined through a process of dialogue between the government, workers, and employers. But the government didn't take into account this procedure and acted unilaterally. Several lawsuits were filed against that decree, and the Council of State provisionally suspended the effects until the judgment is issued. This was due not because of the he opposed to the measure, but because in the rule of law, the end does not justify the means. A just decision made by a party that violates the law is still illegal. Second decision, the limit of a mechanism for citizen participation. Last year, the Council of State also had to decide on the scope of a forum citizen participation, called popular consultation, which is a question that the government asks citizens so that they can vote on the issue of national importance. The President of the Republic intended to consult the people about some legislative measures to reform the labor law without having the prior and favorable consent of the Congress to be able to carry them out. The fundamental question is universal and concerning all us present here. Does direct democracy also have limits? The Council of States was clear in deciding citizen participation is a fundamental right, but the procedure indicated that the political constitution be respected for it to be valid. Otherwise, democracy can become an instrument to ignore the very rules that sustain it. From dialogue to action, a proportional reflection. The challenge of this conference is really that Colombia knows one, and of which we have built concrete institutional response, an independent court with more than 200 years of history and decisions that reinforce the rules, even when that generates political discomfort. But the Colombian experience also teaches us that no court can defend the rule of law alone. Europe found a structural answer. The Association of Councils of State and Supreme Administrative Courts of the European Union. It allows European courts to share jurisprudence, exchange justices, and coordinate common response. This makes the dialogue a permanent structure. The global network of the South has no equivalent. There is the International Association of Higher Administrative Jurisdictions, of which Colombia has been founding member since 1983, but we don't have our own regional space with a defined structure and periodicity. I wonder if this dialogue that the global network of the South couldn't be the starting point for something more permanent, a formal network of cooperation between the high jurisdictions of the global South, which allows us to learn from each other and give common answers to challenges that, as this conference demonstrates, are shared with us. The rule of law is not defended only with sentences. It is also defended with institutions that support each other. Thank you very much.
Thank you, the Honourable Justice Dr. Omar Joaquín Barreto Suárez from the Council of State, Colombia.